Everybody in the U.S. knows this. He's still on the terrorist watch list. He lives in Canada, cannot come to the United States. When Congress asked him to come testify, he had to do it by video conference because the U.S. won't let him into the government. When his case was argued, he couldn't come because he had to be on the telephone. Canada, on the other hand, here's what they do. They say, well, this is really messed up. So they convened a 2-year court of inquiry. 2 years. They scoured all of the documents. They didn't release documents, you know, they had it very tightly controlled. They came up with a determination that he certainly was not a terrorist. So what they did was Stephen Harper, who is no lover of the left, I will point out, he's a right-wing guy. Stephen Harper went on national television, issued an apology to Maher Arar. The Canadian government gave him $10 million in terms of settlement for what their role has been. The U.S., all we got is that he's on the Canadian watch list. They're fighting the case. And we really are looking for two things. We're looking for them to stop the program, and we're looking for an apology for Maher Arar. And these are two things that the U.S. government refuses to do. Yeah?
I have a two-part question.
Okay.
Firstly, doesn't Congress have the right under Article 1 to suspend habeas corpus? And with respect to the warrantless wiretapping program, I had heard that on C-SPAN that the way the program works is the NSA gets information overseas from some of their overseas assets and from the CIA that if somebody in the United States is talking to somebody overseas that's a suspected terrorist, and once they tap that line overseas, they get information on the person who's talking on our side of the ocean on the phone. And that provides the justification that it's not necessarily an unreasonable search and seizure.
Gotcha.
Person. So isn't that the legal justifications being used?
To the two-part question. I hate two-part questions because I always forget the second one. The first one is, doesn't Congress have the right to suspend habeas corpus? And the answer is yes. Congress and the President have the right to suspend habeas corpus, but only in times of insurrection and rebellion. And the government concedes in this argument that this is neither a time of insurrection nor a time of rebellion. And they're saying that Congress, in fact, has not suspended the right of habeas corpus, which is what their legal argument is. With respect to the second question, which has to do with the National Security Agency wiretapping program, I think the young man was saying that his understanding is that people get the intelligence services overseas give information that somebody from the U.S. is talking to somebody that's overseas who's a suspected terrorist. They do the wiretap and they get information on both people. And the question is, isn't that enough reasonable cause or probable cause to be able to wiretap people domestically? To that question, I will sort of answer it this way. The question, you can answer the question from a law enforcement perspective, or you can answer the question from a constitutional perspective. And those are very, very often two different things. And for people that have experience with law enforcement, that the goal of constitutional prohibitions and things like the Fourth Amendment is designed to rein in law enforcement. It doesn't matter whether you're talking about Teaneck Township, or you're talking about New York City, or you're talking about the NSA. There's always a tension between what the Constitution prohibits and what law enforcement thinks that it needs to do, to do these things. Let me take a step back to 1976. In 1976, you needed a wiretap. You needed a federal judge to issue a warrant for wiretaps. In 1976, they passed a law called the Foreign Intelligence Surveillance Act, which created a secret court. Secret court. Nobody, not only could none of us go to the secret court, none of us could know any of the judges that were on the secret court, and that the government could go to the secret court and say, here's the information that we have. So the secret court would issue a warrant, and then they're off to the races. Back in 1976, this is the worst thing that could ever happen. A secret court in the United States, what's that about? Well, here we are in 2008, and we pine for the day, oh, if only a secret court would issue a warrant for a wiretap. What we have, my answer to your question is that due process and the constitutional limitations of due process in our society cannot be solely defined by law enforcement. The Attorney General is the only person that gets to determine whether there is sufficient information under this wiretapping law for people to be wiretapped. And in our system of government, you cannot, under the provisions of the Fourth Amendment, you can't have anyone in law enforcement that is essentially judge, jury, and executioner over who gets wiretapped and what type of surveillance the law enforcement has, that there has to be some sort of judicial oversight as a check on that law enforcement authority. Anyway, I just want to thank you all very much for coming and for the excellent questions. Thank you.